in accordance with international law. Certain states fabricated the issue of freedom of navigation in the South China Sea and imposed its unilateral interpretation of this principle on other states as an excuse to justify its own military presence in relevant maritime area and to allow its warships to enjoy the freedom and mobility to sail in and out of other countries' territorial waters beyond what is allowed in the Law of the Sea Convention. This is not only a challenge and threat to the UNCLOS and the international maritime order, but also will undermine the sovereignty and security of various coastal states. With respect to IUU fishing, China has conducted extensive work in respect of domestic legislation and governance, international cooperation, and implementation of international obligations in fighting IUU fishing. China is of the view that IUU fishing, in essence, is a matter of law enforcement in the process of fishing management. Within the framework of law enforcement against IUU fishing, we should adhere to the existing definition of IUU fishing by FAO and caution against expanding the scope of the definition for other purposes. China is of the view that we should exercise caution with the use of the terms such as fishing industries-related crime. The meaning of such term is not clear. Crimes like smuggling, drug trafficking, and money laundering could be committed in various industries, including fishing. However, the nature of the crime is not relevant to fishing industry. We should not identify them with each other so as not to pose challenges to the implementation of the existing mechanisms. Thank you, Mr. President.
Thank you, the Honorable Delegation of People's Republic of China. I followed the interventions, the suggestions. We look forward to reading in detail your presentation at a later time. Now, with that intervention from the People's Republic of China, we have come to the end of our discussion on law of the sea. The next items on the agenda are actually two. One is on international trade and investment law. And the other one is on report on the work of the Aalco Regional Arbitration Centers. On the first one, international trade and investment law, the experts who had been invited to come and make this presentation have not arrived yet. We hope they can arrive in Dar es Salaam in the course of the day, but in their absence, we cannot have meaningful discussion on this subject. I therefore suggest that we move on to the second topic, which is related to the report of the work of Aalco Regional Arbitration Centers. Some of the directors are here. Not all of them are here, but we could begin with the directors who are already here. And I am asking the Secretary to give us further guidance on this subject.
Mr. President, indeed, we are at the moment, we expected to have 3 directors with us, but as of now, I'm informed that we only have 1 director from the Nairobi Center. And I would suggest that since this is more of an administrative matter and usually open only to member states, and I'm informed that at the moment, we only have member states in the audience, I would recommend that the report from Nairobi Center be presented, and in the course of the day, as the other directors will come, and then the decision will be taken accordingly, Mr. President.
Thank you, Secretary General. I now welcome the Director of the Regional Center of Nairobi to make the presentation on arbitration. Atakuja mbele au? Anakuja hapa? Awesome.
Mr. President, Mr. Vice President, the Secretary General, distinguished delegates, observer states, international organizations and agencies, ladies and gentlemen, permit me, Mr. President, to echo the sentiments of the delegations that have spoken before me to congratulate you and the Vice President on your election to steer the 58th session of Aalco. I also wish to appreciate the Secretary General and the Aalco Secretariat for the excellent preparatory documents and organization of this session and the support to the activities of the regional arbitration centers during the last session. As one of the 5 regional arbitration centers, we, the Nairobi Center for International Arbitration, are privileged to be invited to report on our activities at this session. We thank the government of the Republic of Tanzania for the warm and friendly welcome and hospitality extended to us in this historic city of Dar es Salaam. Mr. President, it may be recalled that during the 45th annual session of Aalco, held at New Delhi on 3rd April 2006, the then Secretary General of Aalco and the Attorney General of the Republic of Kenya signed the Memorandum of Understanding for the establishment of the Regional Center for Arbitration in Nairobi, Kenya. In pursuance to the MOU, an agreement establishing the Nairobi Regional Arbitration Center for Arbitration was signed between the then Secretary General of Aalco and the Attorney General of the Republic of Kenya during the 46th annual session of Aalco held at Cape Town, Republic of South Africa in July 2007. During the 54th annual session in Beijing, China, 2015, the head of the delegation of the Republic of Kenya noted that the government of Kenya had shown its commitment to establishing a regional center by enactment of the Nairobi Center for International Arbitration Act, number 26 of 2013, to establish the Nairobi Center for International Arbitration, commonly referred to NCIA. Mr. President, distinguished delegates, in fulfilling the ideals of Aalco regional arbitration centers, I wish to highlight key activities that we have undertaken during the last concluded 57th session. On the national front, and in keeping with the mandate of Aalco regional arbitration centers to promote the practice of international commercial arbitration and other forms of dispute resolution, the center held 4 sectoral breakfast roundtable meetings to engage the NCIA arbitration rules users with a view to improving the efficacy of the case administration process. The meetings were held on a monthly basis from March to June 2019. The Nairobi Center participated in the 6th Devolution Conference held on 4th to 6th March 2019. Participation in the conference provided an opportunity for the center to create awareness in our lead on our lead role on intergovernmental dispute resolution and reiterated its role in creating an enabling environment towards the achievement of the Sustainable Development Goal 16.3 on access to justice for all. In the region, the Center participated in the first annual International Arbitration Conference from 3rd to 4th April 2019. The conference was organized by the African Arbitration Association, which was held at the Kigali Convention Center in Kigali, Rwanda. The center was part of the panel in the conference discussing, and I quote, the use of African arbitration institutions. The Pan-African Investment Code paves the way, end quote. The conference provided an opportunity for the center to create awareness of its services for participants to learn about emerging issues in the realm of arbitration. Mr. President, the Nairobi Center also took part in the China-Africa Summit from the 16th to the 18th September 2018. The summit was co-hosted by the Supreme People's Court of China, the United Nations Commission on International Trade Law, China Council for the Promotion of International Trade, and the China International Economic and Trade Arbitration Commission. Participation offered an opportunity for business development through Sino-Africa dispute resolution, assessment of the e-tech case management model, and progress discussions with CETAC for purposes of collaborations. Later in the year, Mr. President, the Nairobi Center participated in the Aalco seminar dubbed, and I quote, reviewing international reforms to the investment regime and to the investor-state dispute settlement mechanism, perspective from the Asian-African regions, end quote. This was held between the 19th and 21st of November 2018 at the Arusha International Conference Center in Arusha, United Republic of Tanzania. The center participated in the Chartered Institute of Arbitrators Kenya Branch International Conference from the 8th to 9th November 2018 in Diani, Kenya, with discussions on challenges and opportunities ADR presents in the resolution of disputes at domestic and international levels. On collaborations, Mr. President, the center continues to collaborate with the Judiciary of the Republic of Kenya in the development of a national alternative dispute resolution policy in Kenya. The collaboration has culminated in national alternative dispute resolution stakeholder forums to discuss the proposal of a national alternative dispute resolution policy in Kenya. These forums were held in April and July 2019. Mr. President, distinguished delegates, the center signed a memorandum of understanding with our sister Aalco Regional Center, the Cairo Regional Center for International Commercial Arbitration, in August 2019. The MOU serves to deepen the mutual knowledge and understanding of our respective institutions and develop a positive and mutually beneficial relationship in different fields. It is our hope that similar platforms will be concluded with other Aalco centers in the near future. On education activities, Mr. President, the Nairobi Center organized its first ever regional investment arbitration moot competition on the 30th and 31st May 2019, dubbed, and I quote, Preparing the Future Today, end quote. The competition brought together law faculties from the East African region and pitted the best law schools against each other, with each team bringing their A game in a friendly and competitive environment. More than 20 teams were registered, with participants drawn from universities from Kenya, Tanzania, Uganda, and Rwanda. I'm pleased, Mr. President, to report that University of Dar es Salaam from the United Republic of Tanzania participated in the event, amongst others. The judges were drawn from top law firms within the region with a view of ensuring fairness and impartiality. This is easily the singular platform that currently promotes healthy competitions amongst young lawyers in Kenya, whilst fine-tuning their advocacy skills. The Nairobi Center is always seeking to nurture and support young lawyers through such initiative and plans to go bigger and organize an all-African arbitration moot competition. On administration of disputes, Mr. President, the year 2018-2019 has continued to record a growth in reference of disputes for the administration by the center. The dispute totaled in value at USD 2.9 million and varied in nature from supply and delivery contracts, constructions, and other commercial agreements. In promoting diversity and neutrality, the Center in the year 2018-2019 empaneled arbitrators drawn from different nationalities. The arbitrator selection for the panel was undertaken throughout the year according to the panel listing standard criteria that includes qualifications, training, and experience in arbitration. On the planned activities for the Nairobi Center, Mr. President, the Nairobi Center plans to conclude the process of formulation of an alternative dispute resolution policy through consultative forums by November 2019. Mr. President, distinguished delegates, the Nairobi Center is scheduled to hold its second International Arbitration Conference, and we take this opportunity to extend our warm invitation to all delegates and dispute resolution fraternity in our respective countries to join us on the second NCIA International Arbitration Conference, themed, and I quote, "Tracking Africa's Arbitration and ADR, Its Business Unusual," end quote, to be held in the beautiful coastal city of Mombasa on the 4th to 6th March 2020. In conclusion, Mr. President, we as a center remain at the service of our countries and call upon members to take advantage of the centers within the region. I thank you, Mr. President.
Thank you, Director, from our Regional Arbitration Center of Nairobi. I understand you all have copies of these reports, even from other centers, for those who are not here. But after this presentation, if there are any comments from the floor, you are most welcome on the Nairobi Arbitration Center report. Or if there are questions, please do ask. Well, in the absence of any comments from the floor, let me give back the floor to the Secretariat, who may want to come up with some suggestion of how to proceed from here.
Mr. President, the report from arbitration centers are all included in our Secretariat brief to this effect. However, it has been a custom and our practice to give directors of the centers opportunity to present their report during the annual session. And accordingly, I would recommend that when the other directors come to the audience, then we should give them a platform to present their report. At the same time, the remaining agenda items is international trade and investment law. Again, on this aspect, we expected 3 experts to speak, and we only have 1 expert in the audience. With your permission, Mr. President, I would recommend that the expert available should be given opportunity to present, and then member states should also be invited to make their interventions, if any. And then later on, if other experts comes, then the appropriate decision will also be taken. I present.
Thank you, Secretary General. Let me invite the expert on trade and investment who is in the room to come and make the presentation. Tujue ni nani. Let me ask you to introduce our expert on trade and investment, please.
Thank you, Mr. President. The expert on the dais is Dr. Aniruddha Rajput, the member of the United Nations International Law Commission from the Republic of India.
Thank you. Mr. President, Mr. Vice President, Excellencies, ladies and gentlemen. It is indeed a distinct honor to be here wearing a different hat altogether at this moment, or probably a distinct honor for getting to address you all the second time. This time I intend to speak on mediation in investment arbitration, which is a topic that has been allotted to me. And I'll try to address it in the span of 10 minutes. There's no doubt that the field of investment arbitration is undergoing a moment of crisis. Many scholars define it as a state of backlash. That's where states are responding because they are unhappy with the system of investment treaty arbitration. In order to understand what mediation can offer, we need to firstly understand what really that dispute or controversy is about. For a long time, the perception was that in order to promote foreign investment, you need to have a compulsory dispute resolution clause. There are several studies which are inconclusive, and they say conclusively that it cannot be said finally whether having a dispute resolution clause or a compulsory dispute resolution clause is by itself sufficient to increase the number of investments that come within a jurisdiction. So we see competition between two values. First, developing countries do need foreign investment, but at the same time, the question is whether the presence of a mandatory or a compulsory dispute resolution, that is a compulsory arbitration clause, is by itself sufficient to promote investments. One possible way forward is to find alternatives whereby foreign investors would be comfortable investing in a state and have some sort of mechanism which gives them an assurance that in case of mistreatment in a host state or losses arising out of governmental actions would be addressed in one way or another. The new area which is emerging, which has been rather ignored for a very long time, is what is the role that mediation can perform in relation to resolution of these disputes, in particular investment treaty arbitration disputes. We do not find any reference or discussion on mediation until recently. A major change which has been sought to be brought about in relation to introduction of mediation provisions has been by the European Union. European Union has its own legislation, internal legislation, which insists on mediation of commercial disputes. At the same time, China has several measures within its domestic legal system in relation to promotion of mediation. But trying to use mediation as a mechanism for resolution of investment disputes is something which is underexplored and still in the process of experimentation. The examples that come to mind are the new investment treaties which are being entered into by some states. The prominent example is the China-EU Free Trade Agreement. It is a free trade agreement, so it deals with several aspects of free trade and has a chapter on investment protection. The chapter on investment protection contains a mandatory dispute resolution clause. But along with the mandatory dispute resolution clause, by which I mean a compulsory arbitration clause, there is also a provision which says that in case of a dispute, the foreign investor and the host state should enter into a process of mediation. The China-Vietnam Free Trade Agreement has a provision on mediation as well, which is a far more advanced provision than what is contained in the China-EU Free Trade Agreement. Despite these references to mediation, one cannot forget that these references are primarily voluntary. It is up to the state and the foreign investor, if and when they have a dispute, to decide whether to go for mediation. But then the question is, what is the precise meaning of mediation? Mediation, as classically understood, is a process of facilitating the disputing parties to arrive at a mutually agreed solution through the involvement of a third party. Like arbitration, there is a third party, but the role, function, and the extent of involvement of the third party in mediation is distinct from as compared to what it is in arbitration. In arbitration, the third party is actually involved in deciding the dispute, but in mediation, the third party's objective or its presence is aimed at ensuring that the parties arrive at a mutually agreed solution, basically have their own agreement. There's another term which has been used for some time, rather which has been of use for a much extensive practice, which is of conciliation. The International Center for Settlement of Investment Disputes, the ICSID, has its own conciliation rules. There have been around 6 or 7 conciliation proceedings conducted under the ICSID, but none of them were successful. Because conciliation follows the same format as arbitration, but the only difference is that unlike arbitration, there is no binding decision given in a conciliation proceeding. For those who are aware of the conciliation proceedings of UNCLOS, we just had one example between Australia and Timor-Leste where a dispute was resolved through conciliation. A very similar format is followed in conciliation of investment disputes. But it is heavily procedure loaded. There are pleadings, there are objections to jurisdiction, so conciliation proceedings by themselves tend to take at least 3 or 4 years. If a process is taking 3 or 4 years, by its very nature, it tends to defeat the objective of having an alternative dispute resolution procedure, a procedure which is swift, efficient, less time consuming, and much cheaper as compared to a traditional dispute resolution process. Mediation is certainly quite distinct in relation to conciliation, although the final outcome in both the processes is that the parties arrive at a conclusion by their mutual agreement and not based on a decision or a binding decision of a third party. Despite the difference between mediation and conciliation, it is quite possible that the body or an individual, which is normally the case, who functions as a mediator, might be more active in trying to persuade parties to arrive at a settlement. Therefore, a mediator can very much perform the functions of a conciliator, but without following the strict procedures which would be normally followed in a conciliation proceeding. At the moment, as we see, there are very few bilateral investment treaties which provide for mediation. Mediation is certainly an option which can be explored in the future, as several states are trying to consider their existing bilateral investment treaties, in a way reconsider, redraft, remodel their model bilateral investment treaties. This is a good opportunity to reflect upon trying to have a provision on mediation in their bilateral investment treaties or their free trade agreements with an investment chapter. The question is what form such a mediation clause may or ought to take. At the moment, if we look at most of the bilateral investment treaties, they contain what is called a cooling off period. A cooling off period is a period of 6 months after disputes have arisen, or normally a period of 1 year after disputes have arisen, when nothing is supposed to be done. As the word represents cooling off, means that the parties are expected to cool down, reflect more, negotiate, and resolve the dispute peacefully. The experience is often the investor and the host state don't end up having any conclusion. It is therefore helpful, or it could rather be advisable, to replace that cooling off period with a clause on mediation. The mediation could be compulsory, so that there is a persuasion on behalf of the foreign investors to mandatorily go through the mediation process and possibly find a peaceful solution which is mutually agreeable to the host state as well as to the foreign investor. There is a scope to replace that cooling off period or the period of 6 months or an year with a mediation provision in that place. But the path of mediation is not all that easy. there could be several problems as one proceeds with mediation. The first problem, or a first challenge, so to say, rather than a problem, is the choice between confidentiality and transparency. One of the major criticisms of investment arbitration today is that the proceedings are confidential. Public does not get to know what is happening in arbitration proceedings. This is extremely important as opposed to commercial arbitration where both the parties are private bodies. In the case of investment arbitration, since a state is involved, instrumentalities of state are involved, there are fiscal issues involved, all these issues need to be known to the public. Public has legitimate interest in knowing what is unfolding in an investment treaty arbitration. Therefore, most of the arbitrations tend to be confidential, which is a big problem and which is a big area of criticism of the investment treaty arbitration system. But mediation process is based on concept of confidentiality. There is supposed to be no disclosure when the mediation process is ongoing, because there are proposals, counter proposals, choice of a proposal or choice of another proposal. A mediation cannot be successful if it is put or if it is discussed in public eye. It has to happen in a private conversation. So there is a serious problem of confidentiality which arises in relation to mediation. One solution which has been provided by the International Bar Association in its guideline on mediation of investment disputes is that once mediation conclusion is arrived at, once there is a resolution of the dispute, then that conclusion can be put out in the public domain, although the process by itself need not be. There is a question of having qualified mediators. The task of a mediator is dynamic, it is not mechanical. One can be reminded of two examples from state-to-state mediation. The mediation between Argentina and Chile, the Beagle Channel mediation, which was conducted under the auspices of the Pope, because both the countries were Roman Catholic countries. And the Pope, through his agent, was successful in persuading both the states to arrive at a mutually agreed solution. We also have the example of the Algiers Accord, where Algeria provided its services in relation to providing mediation in resolution of the outstanding dispute. There would be questions of procedure as to what procedure ought to be followed, because one cannot be rigid about the procedure. There has to be sufficient amount of flexibility while arriving at a solution in mediation. We are still at early stages, but this is a time when Asian and African states can move from what they have been understood as rule takers and move to the position of rule makers, which means Asians and African countries can use these provisions of mediation in an innovative way to ensure that the expensive process of arbitration does not begin, or at least is stopped till the time there is a peaceful resolution achieved through a mediation process. If there is an obligation on the foreign investor to undergo a process of mediation, it is quite possible that a resolution of a dispute can be found without going through the arbitration process, which we all know is expensive, which we all know involves a lot of problems which in relation to procedure, the role of arbitrators functioning as counsel, and several other related problems. Mediation would not be a magical wand or a one-stop answer to all the problems that exist in the field of investment arbitration today. But it can remove the stress on the arbitration proceedings. It can try to ensure that a lot of disputes could be resolved peacefully, or at least it provides for a forum to begin negotiations, to begin discussions, which often don't happen. And the experience shows that it is quite possible to arrive at resolution of certain disputes. Certain disputes can certainly not be negotiated. If a state has taken a measure for protection of public health, if a state has taken a measure for protection of the environment, a foreign investor has suffered a loss, there is certainly or probably no reason for a state to get onto the negotiating table. It would be better off for a state to go through the arbitration proceeding and win that arbitration proceeding. But that's not the case in every dispute. There would be several disputes where common ground could be found and there could be a resolution or a peaceful resolution of dispute where parties arrive at a mutually agreed solution. It is a new way. It is a way on which Asian African states could reflect more as to how to incorporate into their investment treaties or free trade agreements. The regional arbitration centers of Aalco can consider how they can contribute towards the mediation process in order to reduce the strain. We are, in a sense, in complicated times, critical times, but the good thing is that the Asian and African countries have been vocal about their concerns in relation to investment arbitration. Mediation could possibly be one of the ways forward. Thank you very much for your kind attention. Thank you.
Thank you very much for your very powerful intervention on the subject arbitration, mediation, reconciliation, with special emphasis on mediation. From the applause, I read that you have appreciated this presentation. I'm sure there might be some comments from the floor. The first one is from Indonesia. Indonesia, you're welcome to take the floor.
Thank you, Mr. President, Mr. Vice President, and Mr. Secretary General. Thank you for the time allocated for us. On behalf of the Indonesian delegation, allow me to deliver our intervention on the issue of international trade and investment laws. As we all are aware, recent development depicts the increase of uncertainty in international trade. This is due to, among others, the non-favorable development of global trade, marked by the rise of protectionist measures, trade wars, and actions to debilitate the multilateral trading system. In this regard, Indonesia strongly believes that an open, non-discriminatory, and rule-based multilateral trading system must be maintained and strengthened to make the market more effective and balanced. The international communities are obliged to maintain strong commitments to ensure the well-functioning of trade and also the functioning of WTO. Mr. President, distinguished delegates, Indonesia is also of the view of in establishing a well-mechanism international trade and investment, a dispute settlement mechanism is of most important. Therefore, with the appellate body in the WTO approaching collapse in 2019, Indonesia shares the view that resolving this issue should be prioritized to salvage the whole system within WTO. The WTO dispute settlement mechanism is crucial in maintaining order in the international trade. In this regard, more than 500 dispute cases are submitted by the member countries. Many of those cases are still pending, among others, due to the limitations of the existing WTO dispute settlement mechanisms. Mr. President, distinguished delegates, several members of the WTO have provided proposals on how to resolve this issue. Indonesia welcomes and appreciates the efforts being made by many WTO members to reform the dispute settlement systems through the submission of different proposals. With intensive discussions in Geneva still going on, Indonesia is open to discuss the elements of the proposals, including exploring the fallback position should there be any failure. I thank you.
Thank you very much, Indonesia. China.
Thank you, Mr. President. We thank Dr. Radpur for your excellent presentation. About this item, China have two parts of comments to deliver, which is related regarding to international trade and investment law. At its 50th session in July 2017, the United Nations Commission on International Trade Law, UNCITRAL, decided to authorize its Working Group 3 to discuss the problems existing in the Investor-State Dispute Settlement ISDS mechanism, as well as the need and potential proposals for reforming it. China welcomes the reform initiative proposed by Working Group 3. The present ISDS mechanism plays an important role in protecting the rights and interests of foreign investors and promoting transnational investment. It also helps to build the rule of law into international investment governance. China believes that the ISDS mechanism is one that is generally worth maintaining. However, it has also created many problems in practice, namely, arbitral awards lack stability and predictability. Arbitrators' professionalism and independence are questioned. Third-party funding affects the balance between parties' rights, and the time frames are overly long and the costs overly high. Besides, China supports the stipulation of transparency discipline for third-party funding. The parties involved should disclose related funding on a continuous basis and avoid direct or indirect conflicts of interest between arbitrators and third-party funders. The legal consequences to be borne by the parties involved for failure to fulfill their disclosure obligations should be made clear. Mr. President, the rule-based multilateral trading system with the WTO at its core is the cornerstone of economic globalization and free trade. It has made significant contributions to promoting international trade, economic growth, and sustainable development. Since its accession to the WTO, China has been a staunch supporter of the multilateral trading system, advocating for the WTO to play a greater role in global economic governance and taken firm position against protectionism. At a time when the world economy is undergoing profound change and the multilateral trading system is undermined by rising unilateralism and protectionism, China supports necessary reform of the WTO in order to enhance its authority and efficacy, to build an open world economy, and to pursue a community with a shared future of mankind. To this end, China has put forward 3 basic principles and 5 suggestions on WTO reform. The 3 basic principles are as follows. Firstly, the WTO reform shall preserve the core values of the multilateral trading system. China believes that non-discrimination and openness are the most important core values of the WTO. Secondly, the WTO reform shall safeguard the development interests of developing countries. Thirdly, the WTO reform shall follow the practice of decision-making by consensus. The 5 suggestions are as follows. Firstly, the WTO reform should uphold the primacy of multilateral trading system. Secondly, the priority of the reform is to address the existential problems faced by the WTO. China proposes that the reform should take up and resolve the issue of appellate body member appointment blockage as soon as possible. Thirdly, the reform should address the imbalance of trade rules and respond to the latest developments of our time. Fourthly, the reform should safeguard the special and differential treatment for developing countries. Last but not least, the reform should respect members' development models. Mr. President, China is willing to continue the discussion on these issues within the framework of Aalco with all member states. Thank you.
After China, Vietnam, can you please take the floor?
Thank you, Mr. President. First of all, our delegation would like to thank Aalco Secretariat for the informative report on the topic of international trade and investment law concerning WTO and ISDS reforms. First and foremost, we would like to express our utmost support for the attempts made by international community to improve the transparency and efficiency of WTO and ISDS mechanisms. Since becoming a member of WTO in 2007, Vietnam has made extensive efforts to make the most of multilateral mechanism. Vietnam recognizes that free trade, integration, and economic alignment on regional and international levels would continue to be the dominant trend. In such context, the WTO maintains its central role for providing states with fora and tools to facilitate international trade and settle trade disputes. However, the alarming crisis in this system, mostly caused by the protectionism and trade friction, and particularly in the dispute settlement mechanism, as the report has elaborated, should not be overlooked. And Vietnam is willing to cooperate with other states to accelerate the reform of the WTO, especially of the dispute settlement mechanism. During recent years, Vietnam has experienced a tremendous rise in foreign investment, signing various bilateral and multilateral treaties on investment protection and promotion. It calls for a wide range of changes, from establishing new domestic regulations to promoting sustainable development and environmental protection. However, foreign investment has brought about not only opportunities and prosperity, but also challenges that involve investor-state disputes. At various fora, especially the United Nations Commission on International Trade Law and United Nations Conference on Trade and Development, Vietnam has frequently voiced its concern and support for reform of investor-state dispute settlement mechanism. On this occasion, our delegation would like to share our view on this process. First, Vietnam is of strong view that relevant parties should try to seek every possible solution to the dispute before resorting to arbitration mechanism. Mediation allows both state and investor an ample amount of time for cooling off and finding a solution acceptable to both sides. However, we don't associate with the opinion requiring mediation or good office as mandatory step before arbitration, because we think that unless conducted in good faith, the process of mediation would end up burdening parties, hindering them from arriving at a solution. Therefore, mediation before arbitration should not be obligatory. Second, Vietnam would like to approach the question of third-party funding in a cautious manner because of the possible abuse. It has been our consistent position at the Working Group 3 of UNCITRAL. In case third-party funding is accepted, it should be limited to certain claims to avoid frivolous and bad faith claims, upholding transparency by requiring fully disclosure of funding terms and condition with security for courts, and containing the remedies for non-compliance. To expand our perspectives, Vietnam expects to hear from other Aalco member states as well as legal experts on this matter. I thank you, Mr. President.
Mr. President, Tanzania is part of the international trade legal instruments, including WTO. While implementing these international obligations for investment and business opportunities in many areas for investors, we are also obliged to ensure that we protect our resources and ensure that they are used for the benefit of the people in the United Republic of Tanzania. In that regard, in 2017, we enacted two most celebrated pieces of legislation. One is the Natural Wealth and Resources Permanent Sovereignty Act, which is Act number 5 of 2017, which provides measures intended to ensure that the natural wealth and resources of the United Republic are used for the greatest benefits and welfare of the people of the United Republic by ensuring that all arrangements made by the government protect and secure the interests of the people. More so, the Act requires disputes arising out of investment or engagement in natural wealth or resources be resolved using dispute resolution institutions available in the country. These institutions could be those related to negotiations, mediation, conciliation, arbitration, or litigation. Realizing that in the past, many agreements were made without considering the interests of the people, the government enacted a second legislation, namely the Natural Wealth and Resources Contract Review and Renegotiation of Unconscionable Terms, which is Act number 6 of 2017. This law gives the National Assembly power to review arrangements or engagements made by the government relating to natural wealth and resources, and where it finds any unconscionable terms, it may advise the government to initiate renegotiation of the arrangement or agreement with a view of rectifying the term so found. It is our belief that this legislation will work for the benefit of Tanzanians and investors in creating a win-win situation in accordance with international order and rule of law. The United Republic of Tanzania, therefore, calls upon all Aalco member states to support this course of action and share experiences on how best to achieve the objective which was stated in the United Nations resolution on permanent sovereignty over natural resources, which was passed in 1962, and whose Article 1 states as follows: the right of people and the nations to permanent sovereignty over their natural wealth and resources must be exercised in the interests of the national development and well-being of the people of the state concerned. Mr. Chairman, with this call, we move the motion.
By sharing the details of the two new legislations that have been put in place to protect investment in the country. The next intervention is India.
Thank you, Mr. President. On behalf of the Indian delegation, I take this opportunity to thank the Aalco Secretariat for the preparation of a detailed background document on the topic. We also thank Dr. Rajput for his very useful presentation. On the topic investor-state dispute settlement, the delegation of India has the following comments. India has entered into bilateral investment promotion and protection agreements, BIPA or BITs, with over 80 countries since 1994. However, India terminated the BIPA BITs with countries with whom the initial duration of 10 or 15 years of the said agreements was already over, and which allowed for such a termination. With respect to remaining countries, a request of a joint interpretative statement was issued. Currently, India is in the process of renegotiating with partner countries on a new BIT based on India's new model text. India is also a signatory to FTAs with many partner countries. India's BITs and model BITs do contain provisions on settlement of investor-state disputes. However, none of the investment agreements nor the model BIT provide for permanent courts or tribunals as such. However, under Article 29 of the India's new model BIT, it does mention about developing an institutional mechanism with an appellate body in future for investment treaty disputes. On the question of mediation in investment treaty disputes, Indian investment treaties provide for a cooling off period of 6 months and welcomes mediation as a mode of settlement of disputes. Mr. President, on the reforms of ISDS, India has been of the considered view that it is important to start with a blank canvas to devise a more fair, a more legitimate, and a more self-contained system of ISDS with internal checks and balances to ensure a good quality of decision making. This new system of disputes resolution should also be one which can seamlessly be merged into the current landscape of enforcement of decisions, with possibly one or two tweaks to facilitate better and quicker enforcement. One of the drawbacks of the current landscape of BIT arbitration is the number of inconsistent or even contradictory awards. For instance, on the proper interpretation of umbrella clauses, the effect of an MFN clause, whether the fair and equitable treatment standards only requires the minimum standard under customary international law, or if it is more expansive. Critics also point out to the CME and Lauder cases against the Czech Republic, where the same facts led to two different decisions by two arbitral tribunals. Mr. President, one of the most critical areas in designing a permanent investment court is to relates to its composition, structure, and certainty. The legal and practical challenges to establishing an investment court should not be underestimated. These have been quite exhaustively dealt with under Working Group 3 of UNCITRAL. It is also welcome to have an opt-in clause, unlike in the Mauritius Convention on Transparency in ISDs, where India had raised the issue with the opt-out clause. India welcomes the move to have discussions and deliberations on the proposals for both structural and systematic reforms and further. Mr. President, on the topic WTO reforms, our delegation has the following intervention to make. Marrakesh Agreement establishing the WTO recognizes that international trade is not an end in itself, but a means of contributing to certain objectives, including ensuring that developing countries and LDCs secure a share in international trade commensurate with the needs of their economic development. In order to be widely acceptable, discussions on WTO reform should be premised on the principles of inclusivity and equity, and not serve to widen existing asymmetries in the covered agreements. The core value and basic principles of the multilateral trading system must be preserved and strengthened, particularly with a view to building trust among nations. Mr. President, a functioning, independent, and effective dispute settlement system is indispensable for preserving the rights and obligations of all WTO members and for ensuring that the rules are enforced in a fair and even-handed manner. Without such a system, there would be little incentive to negotiate new rules or to undertake reforms. Therefore, resolution of the appellate body impasse needs to precede other reforms. Mr. President, India reaffirms the centrality of special and differential treatment as a non-negotiable treaty-embedded right for developing members and LDCs. It is essential to preserve special and differential treatment for allowing developing countries the space to formulate their domestic trade policy in a way that helps them to reduce poverty, generate employment, and integrate meaningfully into the global trading system. It is imperative to have an effective and appropriate special and differential treatment for developing countries, providing them with adequate policy space to address their needs of development. To conclude, Mr. President, any reforms in the WTO must be development-centric, preserve the core values of the system, strengthen the provisions of special and differential treatment in existing and future agreements, and preserve the multilateral character of WTO. Thank you, Mr. President.
Oh, sorry. Japan, you have the floor.
Thank you, Mr. President. On behalf of the delegation of Japan, I would like to express our gratitude for Professor Rajput for his in-depth analysis. Japan also would like to underline the importance of international trade and investment laws. My delegation understands that there are three issues identified in agenda, namely WTO reforms, mediation in investment disputes, investment dispute mechanisms reform initiative. First, on the WTO reforms, many states benefit from the free trading system. If the WTO has some problems, the right strategy is not to abandon the framework of the WTO, but to reform it. While lawmaking remains to be important, maintenance of legal framework is gaining greater significance. Dispute settlement system is now a central element of the WTO, and the appellate body in particular plays a pivotal role in the system. However, problems related to the functions of the appellate body have been pointed out by many members. finding a durable solution is in the interest of all members. Second, I will turn on the mediation in investment disputes. Arbitration has been an effective tool to solve investment disputes, and Japan believes it will continue to be so. At the same time, Japan recognizes the concerns such as the cost or the duration of international arbitration, and in this regard, the effectiveness of mediation are being considered recently. As we discuss the use of mediation, we should bear in mind the existing frameworks, provisions of the free trade agreements, bilateral investment treaties, and investment contracts are based on the outcomes of negotiations among the parties concerned to these legal instruments, and dispute settlement procedures are not an exception. Specific procedures, including arbitration, are chosen and stipulated for solving certain disputes. While mediation can certainly add possible method of dispute settlement, it will of course be unrealistic to attempt to replace existing procedures with mediation. Japan would like to continue to consider the possibility of mediation as one of the options regarding the investment dispute settlement mechanism through actively contributing to the discussions, such as on the exit rules amendment. Finally, I refer to the Investment Disputes Mechanisms Reform Initiative. Japan considers the investor-state dispute settlement mechanism needs a balance between protection of investment and states' rights to regulate it. Japan recognizes the trend in international discussions that the current ISDS mechanisms should be reformed. Japan intends to fully engage in the discussions in the Working Group 3 of UNCITRAL so that the discussions on appropriate reform will be conducted without prejudice to the outcome and will appropriately address actual concern. I thank you, Mr. Chairman.
Thank you, Japan, for your major contribution on these ideas. Now I call upon the Islamic Republic of Iran.
Bismillah ar-Rahman ar-Rahim. Mr. President, my delegation would like to thank the Secretariat for preparation of the report on international trade and investment law, which contain various issues on this topic. My intervention may focus on work of UNCITRAL in its working groups. I also commend the briefs presented by experts, especially the analysis presented on mediation by Professor Rajput. Mr. President, we take note with appreciation the progress made in the different working groups of the United Nations Commissions on International Trade Law, UNCITRAL. The Commission has finalized 3 texts that could assist member states to use them in line with their specific needs and circumstances. We appreciate the work of UNCITRAL on expedited arbitration, which is less expensive and faster than standard arbitration, and seems to be more satisfactory for parties to disputes. It is important to increase efficiency of this procedure through ensuring its quality, due process, and fairness. We are also interested in the deliberations on Working Group 3 and its 3-phase mandate concerning reform of investor-state dispute settlement, ISDS. We expect that this working group address the concerns of states and investors with respect to new generation of investment regime through enhancing consistency, access to justice, and fairness. The working group shall come up with concrete recommendations to address the defects of the current system and devise a holistic and comprehensive solution with respect to protection of the rights of people affected by foreign investment, responsibilities of the multinational corporations on human and labor rights, as well as environmental protection and affected individuals and communities. It's also important to ensure full and effective participation of developing countries in this process, taking into account consideration their limited capacities and resources. Mr. President, the critical importance of identity management in facilitating trustworthy e-commerce and other online activities and its legal aspects is now globally well recognized. The Islamic Republic of Iran attaches great importance to this topic, which is currently on the agenda of Working Group 4 Electronic Commerce, and takes note with appreciation the work of Secretariat in preparing a revised draft on the cross-border recognition of identity management and trust services. In this regard, and given the important role of the government and public authorities in development and deployment of IDM systems and the provision of IDM and trust services, it seems premature to neglect the function of public authorities in this field and ignore its efficiencies, particularly in enforcing laws and preventing risk and abuses. Furthermore, in preparing the draft provisions, particular attention should be given to the different levels of economic as well as information and communications technology development of the member states. It is also important to pay duly attention to challenges and concerns of developing countries in cyberspace, especially the subject of privacy. Mr. President, with regard to judicial sale of ships, my delegation takes note of the work of the Secretariat in preparing a revised draft instrument incorporating the outcomes of the deliberations of Working Groups 6. The new draft should address the concern expressed by a member state on the draft text prepared by the Comité Maritime in this regard. We emphasize that in providing the new draft, following crucial points need to be taken into consideration without prejudice to the final form of the instrument, whether that be a guideline or model law. First, right to access to justice, including right preferred creditor, not being prejudiced by providing solutions such as extinguishment of rights by issuing the sale certificate. Second, necessity of acquiring judicial approval for foreign judicial decisions so that the administrative enforcement can take place internally. Third, there should be a contractual link between claimant and the ship for the purposes of the judicial sale. And fourth, it's imperative to exclude state ships from the scope of the draft text. Mr. President, last but not least, it would be remiss of me if I do not mention successful adoption of the United Nations Convention on International Settlement Agreement resulting from mediation called as Singapore Convention in 2018. We actively participated in preparation of this convention and signed that on the signature ceremony. This convention will assist member states and their judicial authorities to settle disputes with increased efficiency, particularly in commercial disputes in which the parties seek stability and reliability. The Islamic Republic of Iran signed this convention on 7th August 2019 at a ceremony hosted by Singapore along with other 45 countries. Finally, we would like to commend the efforts of the UNCITRAL's member states and Secretariat in continuing to promote the development, harmonization, and modernization of international trade and commercial law. I thank you, Mr. President.
Some of these suggestions are so constructive. I hope we shall revisit them when we get the final reports of this intervention. Kenya, please.
Thank you, Mr. President. It is with great honor that I have this opportunity to give the following general remarks on behalf of the Republic of Kenya on this agenda item. Distinguished delegates, the WTO is at the heart of the global trading system to which Kenya is a part of. The WTO is the only international organization that deals with the global rules of trade between nations. The three functions of the WTO, which are administering multilateral trade rules, serving as a forum for trade negotiations, and providing a mechanism to settle trade disputes, are facing challenges that may necessitate reform. The dispute settlement mechanism provides a rules-based process to adjudicate over trade disputes, with all WTO members falling under its jurisdiction. Kenya has not actively participated or utilized the dispute settlement mechanism. This is the case for most of the developing and least developed countries. The main reason for this is the limited technical and financial capacity to access this mechanism. Mr. President, in the recent past, the dispute settlement system has encountered challenges, including the constitution of the appellate body. Should this persist, the appellate body will not have members to hear the cases when the terms of the remaining members come to an end in December. This would therefore render the WTO dispute settlement system less effective. Kenya recognizes and acknowledges the efforts being made by Aalco to address this challenge and to find a solution as to have the appellate body of the WTO dispute settlement mechanism function as was envisaged. We also recognize and support all efforts under the Aalco banner in collecting views towards reforming the WTO. Distinguished delegates, Kenya also recognizes the challenges that abound in the handling of investment dispute settlement, which were highlighted in the just concluded Ancestral Working Group 3. These include the lack of consistency, coherence, predictability of arbitral decisions by investor-state dispute settlement tribunals, concerns pertaining to costs and lengthy proceedings, and the lack of a mechanism to address the frivolous and unmeritorious cases being brought before the tribunals, lack of transparency and regulation on third-party funding, and the impact it has had on different aspects of the ISDS, for instance, in the increase in frivolous claims, the cost of the ISDS, and security for costs. Distinguished delegates, these are indeed some of the challenges that were recently experienced by Kenya during the prosecution of the investor-state arbitration cases that Kenya was party to. Mediation, therefore, as a mechanism of investment dispute settlement should be encouraged with a view to addressing the challenges stated above. We thank the Aalco Secretariat for creating a platform for member states to discuss these challenges and propose possible solutions. Thank you, Mr. President.
Thank you very much indeed. We've had very rich interventions on this very important subject of trade and investment. We should thank Dr. Rajpa. He is the only one who was available to lead us in this discussion by opening the discussion. I'm not sure whether the other experts will appear before the end of the day. But, frankly, your basis of discussion has generated a lot of response from the member states. And this subject, to many of us developing countries, is very, very critical. And I think we shall continue to look upon Aalco as the repository of ideas and bring this subject frequently and as the need may arise to derive issues that might be tapped by member states to bring them into practice when dealing with trade and foreign investment in particular. With these remarks, while thanking Dr. Rajpa, let us take a break of about 45 minutes or 1 hour to allow the Secretariat to compile a number of procedural requirements that may eventually lead us to the end of this session in the course of this morning, hopefully, or before lunch or shortly after lunch. So I invite you to have a break, have coffee, tea, and leave the work behind the scenes to the Secretariat. Maybe, Secretary General, you want to say something before we break? No? Okay, please, let's go and have a break.